Hi everyone. In this topic, we are going to discuss damages arising from contract and damages arising from tort, specifically Civil Code Articles 2197, 2217, 2224, 2226, and 2229. So let us first define damages. The Supreme Court defined the word damages in one case as the pecuniary compensation, recompense, or satisfaction for an injury sustained, or as otherwise expressed, the pecuniary consequences which the law imposes for the breach of some duty or violation of some rights. The word damages involve physical or material, moral or psychological, mental or spiritual, financial, economic, social, political, and religious. It is also important to remember that in actions for damages, courts should award an amount to the winning party and not its equivalent in property. So for example, there was one case where the plaintiffs were ordered jointly and solidarily liable to defendants the quantity of 100 kavans of palay every year. So the Supreme Court deleted that, explaining that 100 kavans of palay as a form of damages cannot be sustained because palay is not a legal currency in the Philippines. So in actions for damages, it should always be in an amount and not equivalent in property. So there are different kinds of damages that may be awarded in this jurisdiction. According to Article 2197 of the Civil Code, damages may be actual or compensatory, moral, nominal, temperate, or moderate damages, liquidated, or exemplary or corrective. We are going to discuss further on these damages in the next few slides. As an additional note, no proof of pecuniary loss is necessary in order that moral, nominal, temperate, liquidated, or exemplary damages may be adjudicated. So this is according to Article 2216 of the Civil Code. And the assessment of such damages, except liquidated ones, because liquidated damages are those agreed upon by parties to a contract to be paid in case of breach. So except liquidated ones is left to the discretion of the court according to the circumstances of each case. And before we proceed also, a person is not always liable in each and every case that there is damage. So we call that damnum absque injuria. If the damage resulted because a person exercised his legal rights, it is damnum absque injuria. So mere damage without injury does not result in liability. In action for damages, courts should award an amount to the winning party, not its equivalent property. So, for example, in one case, the plaintiffs were ordered liable to the defendants the quantity of 100 kavans of palay every year. So the Supreme Court deleted such award, explaining that 100 kavans of palay as a form of damages cannot be sustained because palay is not legal currency in the Philippines. So it's important to remember that courts should award an amount and not its equivalent in property. Actual or compensatory damages. So according to Article 2199 of the Civil Code, provides that except as provided by law or by stipulation, one is entitled to an adequate compensation only for such pecuniary loss suffered by him as he has duly proved. So the purpose of this law in awarding actual damages is to repair the wrong that has been done and to compensate for the injury inflicted. So the actual damages are compensatory only, and the amount should put the plaintiff in the same position as he would have been if the damage or the injury or the wrong did not happen, which he will get in the form of compensation or reparation. In contracts and quasi-contracts, according to Article 2201, the damages for which the obliger who acted in good faith is liable shall be those that are the natural and probable consequences of the breach of the obligation. So in case of fraud, bad faith, or malice, the obliger shall be responsible for all damages which may be reasonably attributed to the non-performance of the obligation. Moral damages. So the Civil Code provides that moral damages include physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. This is according to Article 2217 of the Civil Code. The award of moral damages is designed to compensate the claimants for actual injury and is not meant to enrich the complainant at the expense of the defendant. So, moral damages are not awarded to punish the defendant, but it is awarded to compensate the victim. Now, unlike actual or compensatory damages, no proof of pecuniary loss is necessary in order that moral damages may be adjudicated, since moral damages deal more on physical suffering, mental anguish, so it's not in a form of monetary loss or the one that is stated in actual or compensatory damages. And the assessment of such damages is left to the discretion of the court. However, there must be proof that the defendant caused physical suffering and all these other moral damages to the plaintiff. The law on moral damages found in Articles 2217 to 2220 of the Civil Code is new. The Code Commission observed that the moral damages were not actually expressly recognized in the old Civil Code, although it was observed in one case that such damages have been allowed by the Supreme Court. But since the Commission explained that even though denial of the award of moral damages are incapable of pecuniary estimation, it is unquestionable that the loss or injury is just as real as in other cases. That is why the ends of justice are served by giving the judge the discretion to adjudicate the definite sum for moral damages. So just to add, in the moral damages, so long as there is satisfactory proof of the psychological and mental trauma and all the other damages mentioned in the previous slide suffered by a party, the grant to him of moral damages is warranted and is left to the discretion of the court. So cases when moral damages are allowed. So Article 2219, moral damages may be recovered in the following and analogous cases. So please take note that it is mentioned as analogous cases, as according to Justice Capistrano, the said case or this enumeration does not mention any wrongful omission. And this is because, as pointed out, the enumeration was not, this list was not intended to be complete and exclusive. The Commission explained that if they were to make an exclusive enumeration, it would have required an examination of all the provisions of the Civil Code and the Revised Penal Code. And they simply did not have the time to or inclination to do so. So, meaning the analogous cases should be left to the courts to determine. So, just to further explain on some of the examples here, like for number 3, seduction, abduction, rape, or other lascivious acts, it could be that, just for an example, the parents of the female that was seduced, abducted, raped, or abused can also recover damages. So, an award of moral damages would require certain conditions to be met. So, first, there must be an injury, physical, mental, or psychological, sustained by the claimant. Second, there must be an act or omission established. And then third, the wrongful act or omission of the defendant is the proximate cause of the injury sustained by the claimant. And then fourth, the award of damages is predicated or found on any of the cases stated in Article 2219 and any related cases that is left to the discretion of the court. Unfounded suits. So no damages can be charged on those who may exercise the right to litigate. So moral damages and attorney's fees cannot be assessed against the plaintiff by the mere fact that he filed a case against a defendant as long as it was done in good faith. Although there are instances when award of moral damages as well as attorney's fees is justified if there was a clear abuse of court processes. So for example, a plaintiff has no cause of action against the defendant, and then he recklessly filed the suit, pursued pointless appeals, and therefore it cost the defendant to spend time, money, and efforts in defending himself. So that can be an instance or a case where moral damages and attorney's fees will be justified. For labor cases, moral damages may be recovered where the dismissal of the employee was attended by bad faith, fraud, or an act oppressive to labor. So for example, a waitress was made to perform other chores or duties such as dishwashing or janitorial work, and it led to working long hours without overtime pay. And in the process of being a waitress and while doing those other chores not part of her job description, she developed a condition that would require surgery. Like for example, a carpal tunnel syndrome, let's say. And then after that, she was no longer fit to continue working. And then the employer sent her home without separation pay or compensation. It's one of the examples where damages can be recovered in labor cases. And as for criminal taking of life, no such proof is necessary in case of violent death. So these are for damages that caused for someone to suffer sorrow, pain, and anger, and such violent death would leave them with a feeling of injustice. And so for this reason, moral damages must be awarded in violent cases and criminal taking of life, even in the absence of proof or any allegation. So as for the factors to consider in determining the amount, since this is unlike actual or compensatory damages, there is no hard and fast rule in the determination of what would be a fair amount for the moral damages. However, there are factors specified by law and established by jurisprudence that could affect the amount to be recovered. So it can be the extent of humiliation, the pain and suffering, could be in the nature of the injuries or the degree of suffering endured by the complainant, or it could be considered in the official, political, social, or financial standing. And lastly, there are also persons who may recover. So it means that there are relatives that have also suffered even though they are not the victim of the assault. So those relatives might have suffered mental anguish, serious anxiety, and so they can also recover moral damages. So for nominal damages, the Supreme Court observed that nominal damages is proper whenever there has been a violation of an ascertained legal right, although no actual damages resulted or none are shown. So as an example, there was one case where plaintiffs sued an airline because they failed to transport them to Manila. And then the Supreme Court acknowledged that at that time, the Mount Pinatubo eruption prevented the airline from proceeding to Manila on schedule. However, it was justified that the airline failed to make the necessary arrangements to transport the plaintiffs on the first available connecting flight, and the plaintiffs were obliged to make the necessary arrangement themselves. Therefore, nominal damages were awarded, but it was only in the form of, it was nominal damages because there was no actual proof, and there was an absence of proof of actual damages. And also, it's important to take note that nominal damages cannot coexist with actual or compensatory damages. So it's either actual or compensatory damages or nominal damages if there is an absence of proof. Temperate or moderate damages. This should be or. According to Article 2224, temperate or moderate damages, which are more than nominal but less than compensatory damages, may be recovered when the court finds that some pecuniary loss has been suffered but its amount cannot, from the nature of the case, be provided with certainty. Temperate damages must be reasonable under the circumstance. So there are some cases where proof of pecuniary loss cannot be presented or offered, but the court is convinced that there has been a loss. So rather than the plaintiff suffering without redress from a wrongful act of the defendant, the judge should be empowered to calculate moderate damages in some of the cases. So as an example, the Supreme Court sustained the award of temperate damages to anticipate an increase in future medical expenses. So in actual damages, it cannot cover such adjustments because it generally assumes that at the time of litigation, the injury suffered as a consequence has been completed and that the cost can be liquidated. However, the court concluded that temperate damages should be awarded to meet pecuniary loss certain to be suffered but which could not be made with certainty. So these are for situations where the injury is continuing and there might be possible future complications arising from the injury, and it would be difficult to predict. Liquidated damages. Liquidated damages are those agreed upon by the parties to a contract to be paid in case of breach thereof. So liquidated damages are attached to an obligation in order to ensure performance, and it has a double function. So number one is to provide for liquidated damages, and number two is to strengthen the coercive force of the obligation by the threat of greater responsibility in the event of breach. So for example, there has been a delay in a completion of the project, and so that would breach the contract and the agreement between the parties. So ordinarily, the court cannot change the amount of liquidated damages agreed upon by the parties. However, Article 2227 of the Civil Code provides that liquidated damages, whether intended as indemnity or a penalty, shall be equitably reduced if they are iniquitous or morally wrong. So there are still some cases, even though there is an agreement in the contract, that the law will be determining the measure of damages and not based on the stipulation. Exemplary or corrective damages. So these are imposed by way of example or correction for the public good, in addition to the moral, temperate, liquidated, or compensatory damages. So take note of the word in addition. Unlike nominal damages mentioned earlier, it cannot coexist with actual or compensatory damages, while exemplary or corrective damages is imposed in addition to either moral, temperate, liquidated, or compensatory damages. While the amount is not necessarily needed to be proved, the plaintiff must show that he was entitled to either moral, temperate, or compensatory damages before the court may consider the question of whether exemplary damages should be awarded. So to simply explain, you can focus on the word corrective, meaning the intention is for this to serve as a deterrent to serious wrongdoings or discourage someone from doing something.